My name's Ken Swinton, and today I'm going to speak about the Scottish Standard Clauses 5th edition, Clause 29, which is headed Green Deal, etc. Now, at the time of recording this in October 2024, I understand that a new 6th edition will be coming out shortly. Nonetheless, I think it's worthwhile to have a look at this clause, as I expect the newer edition to be in very similar terms. So, first of all, let's have a look at clause 29, headed Green Deal, etc. 29.1 says the property is not subject to a Green Deal plan as defined in Section 1 of the Energy Act 2011. Section 29.2 deals with delivery of the Energy Performance Certificate and seems to be honoured more in the breach than anything else because it's never delivered at settlement of the transaction. There is, of course, an EPC contained within the home report, which the purchaser will have available to them. And then in 29.3, there's the statement that the property does not benefit from, contain, or have attached to it any solar panels or other electricity microgeneration installation. And that set me wondering why, when there is so much emphasis on climate change, energy efficiency, fuel costs, and so on, that subclauses in section 29 of the standard clauses are negative in relation to solar panels. Why should this be? So what I'm going to do is I'm going to look at this under a number of chapters, as it were. Firstly, what do we mean by solar panels? Secondly, I'm going to look at the property law considerations that are relevant. I'm going to look at warranties in the missives, planning permission considerations, and building warrant considerations in relation to solar panels. And then finally, I will look at feed-in tariff, which has now ceased, and the Green Deal, again, which has now ceased. And we'll say something about the problems associated with so-called rent-a-roof schemes. And then finally, I'll provide something in the way of a checklist to look for if there are solar panels installed on a property. Now, one of the things that I would say is, as conveyancers, we are not experts in things like electricity tariffs, and we shouldn't purport to be expert in these particular areas. So I'm looking at the property law and contract situations, and I don't think we should be offering advice on things that we are not expert in, such as feed-in tariffs in particular. What we're speaking about here are photovoltaic solar panels, and this picture nicely illustrates photovoltaic solar panels, but also in the top right corner of the roof in this case, there are tubes used for heating hot water or preheating hot water using solar energy. I am not speaking about those at all in this talk. This slide illustrates how solar panels work. They really are very straightforward. The sun's rays hit the solar panel, creating electricity. That electricity is direct current. It is converted through the DC-AC inverter, then runs through the meter, and then runs into the mains in the house. Any unused electricity is exported to the grid, and that passes through a second meter there, showing exports. With feed-in tariffs and with export tariffs now offered by energy companies, there may be payments for any energy that is exported. So the first question, the property law question, which is at the center of this, is whether solar panels are fittings or fixtures. The leading authority now is Scottish Discount Company against Blinn in 1985. This was a court of 7 judges, so it is a very authoritative decision and offers the leading modern authority on what constitutes something that has become annexed to the property and therefore accedes to the property, and for which no separate title therefore exists. As such, it overrules the Cliff Plant case of 1981 and offers a reinterpretation of what used to be the leading authority, and in some ways still is the leading authority, that is Brand's Trustees from 1876. Although Brand's Trustees deals with mining equipment in relation to a mining lease. So now we have 3 tests to determine whether something has become part of the property. And those 3 tests are the degree of physical attachment, the functional subordination of what has become attached, and the permanence, or perhaps better saying quasi-permanence, of what has been attached. So if we consider each of these in turn, the first of these is physical attachment, and we can divide that into subtests. Is it clearly and firmly attached? And with solar panels bolted to the roof, I think we can say that it is clearly and firmly attached. The fact that it can be dismantled with comparatively little effort and taking little time does not prevent it being attached. We can also consider that it has become attached to and become an integral part of the electrical system of the house. So in my view, the test of physical attachment is clearly satisfied. The next is functional subordination. The functions which solar panels form is only one. They generate electricity, which is used within the house. That clearly is beneficial to the occupants of the property, and it has become an integral part of the wiring system in the house. And I don't think anyone would argue that wiring systems form part of the property itself once installed. The final test is permanence, or at least quasi-permanence. And if we go back to Brand's trustee, it's probably better illustrated in that case. There was a lease of 19 years, and the tenant's fittings in relation to the mine were treated as heritable. So if you've an arrangement which lasts at least 19 years, and perhaps shorter than 19 years, it is clear that it will satisfy the Brand trustee test of permanence or semi-permanence. When we look at feed-in tariff contracts, they had a 25-year duration, and it seems perfectly clear that the test of permanence or semi-permanence is in fact met in such cases. So the panels have acceded to the heritage. In law, they form part of the fabric of the property and will pass with the property, whether mentioned or not, in the extensive list of fittings and fixtures contained in the standard clauses. So it's difficult in some ways to square what's said in section 29.3 with the law. If there are panels there, they will become part of the property of the purchaser simply by being there. The next contractual consideration we have to consider is in what is currently condition 4.1 of the 5th edition of the standard clauses, and I've highlighted in a slightly different colour the relevant wording. The seller undertakes that any systems, in this case electrical systems, forming part of the property or electrical appliances, whether of a movable or integrated nature, included in the price will be in working order commensurate with the age as at the date of settlement. Now, electrical appliances was clearly intended to cover built-in kitchen appliances at some stage, but it's quite general in its wording and seems to be broad enough to include solar panels. So if there are solar panels on the property, the seller undertakes that they are in working order commensurate with age. I understand that there is some deterioration of the output of solar panels over time, but the with age qualification will apply in that situation. The next matter which I want to consider is whether or not planning consent is required for the installation of solar panels. And here we have a statutory instrument, Scottish statutory instrument, Town and Country Planning, General Permitted Development, Domestic Microgeneration, Scotland, Amendment Order 2009, SSI 34. And this broadly provides that there is no requirement for planning permission for the installation of solar panels. That is subject to a series of exceptions. So where solar panels are installed on a pitched roof or on a wall and protrude more than 200 millimeters above the plane of the roof or beyond the walls, or above the highest point of the roof, then planning permission will be required. But if the building is in fact flat, they must not be mounted on the walls at all. If they have been placed on a flat roof, they must not protrude more than 1 meter above the flat plane of the roof, nor must they be installed within 1 meter of any edges of the flat roof section. If the property is located in a conservation area, then the rules for conservation areas are somewhat different. The solar panels must not be on the main elevation of the property. They must not be visible from any road, which could be a tricky one. And they must be sited to minimize impact on the amenity of the area and must be removed from the roof when microgeneration ceases. So there's an obligation to uninstall, as it were, the solar panels when they are no longer being used. With listed buildings, planning consent will be required as normal, and the usual considerations which apply in relation to listed buildings will apply. It will depend on both the local authority and Historic Environment Scotland. And again, it will depend whether the building is category A, B, or C. If we then turn to building warrant, then we can look at the building warrant regulations, and these provide that there is no requirement for a building warrant where the equipment is installed on a house with a story no more than 5 meters above the ground. Now, this isn't the roof level, this is a story. So if the building exceeds 2 stories, so that would be 9 meters, still quite tall for a 2-story house. But if you had a Georgian house, you might well have rooms that come to that sort of height. So it's something to bear in mind. The next consideration for building warrant is that the building owner must satisfy themselves that the existing structure is capable of taking any additional loadings from the proposed installation. Now, the average property owner isn't in a position to satisfy himself about loadings at all. That seems to me exclusively a matter for a structural engineer or perhaps an architect. And the regulations provide that a structural appraisal of any existing structure should be undertaken by a person competent before the installation is installed. I suspect that's honoured again in the breach rather than anything else. I don't suspect that companies that sell solar panels carry out any structural inspection. The Scottish Government, I should say, Building Standards Division have guidance in addition to the actual regulations itself. And they suggest that where a single row of panels is installed, then there will be an increase in load to the roof trusses, but this should normally be within acceptable tolerances. So it shouldn't need any different considerations. However, where multiple rows of photovoltaic cells are installed on a roof, which seems to be the norm, then a detailed assessment should be undertaken, which may require a structural engineer. So that's available on the Scottish Government website, the Directorate for Built Environment Building Standards Division. And I've put up the reference to that on this slide. So the next matter that I would like to address very briefly is in relation to buildings insurance taken out by the purchaser of the property. There appears to be no industry-wide practice whereby solar panels are included automatically in buildings insurance. I checked 3 or 4 insurers and they did provide cover for solar panels. So it's certainly worth checking whether there are any exclusions in relation to solar panels. And of course, anyone who takes out insurance is under a general duty of disclosure. So if in doubt, disclose, I think, is the safest option to adopt. I don't think there's any specific advice that needs to be given, but these are just things that a purchaser would need to bear in mind. The purchaser should also bear in mind the reinstatement value of the property. Solar panels are not cheap, and their replacement in the event of damage to property would run into thousands of pounds. So it's important to ensure that the reinstatement value is sufficient to cover replacement of solar panels as well as everything else. Sorry about that. The slides weren't forwarding there. I now want to speak about different schemes involving solar panels. And these can be divided by time and also divided in other ways. So before the 1st of April 2010, there were no feed-in tariffs available, and the feed-in tariff was something that was paid by the government. They last for 25 years. So those systems that are in place and are covered by FIT will continue to be covered by FIT. Even after 2010, there may be installations which were never submitted to the government scheme and therefore do not qualify for feed-in tariffs. The feed-in tariff system closed to new applications on 1st of April 2019, with systems required to be installed by 31st December 2019. And subsequent to that, we've got Smart Export Guarantee, which started on the 1st of January 2020. Energy companies are obliged to offer a smart export guarantee for any electricity that is exported to the grid. It's a government obligation, but it's really up to the particular companies to choose their amounts which they're prepared to pay. So if we go back and look at FIT systems covering that period from 1st of April 2010 to 31st December 2019, they may be owned outright. The purchaser may have paid cash for them, or they may have taken out an unsecured or even a secured loan to pay for the cost of the system which is installed. The system may be subject to the rent-a-roof scheme, and I'll come back and deal with that on the next slide. And FIT systems could also be installed under the Green Deal. And again, I'll speak about the Green Deal a little later. So if we look at rent-a-roof schemes, here the installer installs the solar panels on the roof of a property without any payment from the home owner. The home owner takes out the FIT contract. Of course, we can't do that anymore, but then assigns the benefit of the FIT contract, the right to receive payment for electricity generated by the panels, whether consumed in the property or exported back to the grid, for the full 25-year period. The installer obviously bears the capital cost of the units and the cost of installation. The owner of the property grants the installer a free 25-year lease and assigns to the installer the right to collect the FIT payments. The owner, of course, gets the benefit of free electricity which is generated. Now, in England, the installer registered leases of the roof space in the land registry, and it's believed that there are around 27,000 instances of rent-a-roof schemes still outstanding in England. It's not known how many, if any, are outstanding in Scotland, and I suspect there aren't any that need to cause any concern. But I'll speak about what the problems are in Scotland just to provide an idea. So if we look at rent-a-roof schemes under Scots law, there are various obstacles to creating such a lease of the area above the roof, and then registering that lease in the land register. The first of those obstacles is the Land Tenure Reform Scotland Act 1974, Section 8, which is often forgotten about. I'll also speak about the Title Conditions Act 2003, both in relation to real burdens and servitudes. And I'll say a little bit about the Tenement Scotland Act 2004, particularly sections 28 and 26 and perhaps 29 as well. And then I'll deal a little bit again with the Land Registration Scotland Act 2012, section 22. Now, on land registration, there was nothing in the 1979 Act, obviously, dealing with rent-a-roof schemes, but the knowledge base on Registers of Scotland at the time, these became common, required that any potential rent-a-roof case be referred to a senior member of staff at the registers so that they might consider it. So they clearly were recognised as problem areas. The principal difficulty that someone faces is that FIT contracts are for a 25-year period, and the installer would want the benefit of it for the full 25-year period. However, Section 8, subsection 1 of the 1974 Act provides that no part of a property which is subject to a lease shall be used as or as part of a private dwelling house, with the result that on a private dwelling house, it is simply not possible to register a lease of the roof space, bar any other considerations because of Section 8.1. That doesn't prevent, of course, a license of the right to attach the panels to the roof without payment, and an assignation of the right to collect the FIT payments in respect of the microgeneration However, a license is not real, and the obligations would not automatically transmit to a new owner. I might also mention in passing the Leases Act 1449. A lease requires a tenant to be in possession to give security of tenure under the 1449 Act, and there is no possession of the panels on the roof by a third party, although the right to collect the payments, which I don't think is an indicator of ownership, it's an indication of a separate contract entered into between the homeowner and effectively the government. So I'm pretty certain that there is no possession and it couldn't be a real right under the 1449 Act. So it's clear that you can't register under the 2012 Act. I'll come back to that a little later. Section 26 of the Tenement Act 2004 provides a definition of a tenement, and provides that there require to be 2 flats at least for there to be a tenement, which are designed to be in separate ownership. I don't think the solar panels attached to a roof are in separate ownership. Now, it's debatable whether the second test, the division horizontally, is met, because in most cases the roof will be sloping. So I don't think it's possible to have a title to the solar panels as a flat in the tenement. Section 29 defines a flat as being intended to be used for residential purposes or on one floor. It doesn't have to be residential purposes, but clearly it isn't residential purposes. I don't think things strapped to a roof are actually situated on one floor. So I'm pretty confident that the Tenement Act excludes the creation of a separate interest under the Act in respect of panels on the roof. When we look at the Title Conditions Act, real burdens are dealt with in Part 1 of the Act, but a feature for any burden which exists, or is created, I should say, after the Act came into force on 28th November 2004, is dual registration of the benefited and burdened properties in relation to the terms of the real burden. Now, for the reasons that I've already stated, it's not possible to create a separate interest in land, and therefore thing created by way of agreement between the installer and the homeowner would constitute a real burden. Similarly, for servitudes, the Title Conditions Act, Section 75, provides that any supposed rule of servitude law that only known servitudes can be created is abolished, but case law has suggested that there is no such rule in any event. But again, it requires dual interests, a benefited property and a burdened property, and we simply can't establish a property. If we can't establish a property, it can't be a servitude. Okay, rent-a-roof problems have occurred in England. Leases have been registered, and the difficulty on both remortgage and on sale of the property is that unless the terms of the lease are appropriately qualified, it may rank ahead of subsequent security. In Scotland, there are obviously similar problems under the 1970 Act, and in relation to the Trade Development Bank cases, it adopted a test of which real right is created first, although that is then qualified on the basis of good faith. So if there's a knowledge that another right might be created, then it's arguable that could be effective. It's something to bear in mind. As I say, I don't think there will be any rent-a-roof problems in Scotland. Obviously, in England, where we have these instances, still 27,000 that haven't been unwound in some way, The assignation of the right to collect the FIT payments was assigned by the owner to the installer. But of course, the installer has to lay out the capital costs of installing the system and buying the units in the first place. That will place a strain on the installer, and once numbers start to build up, it is natural that they will want to receive a capital sum back to cover the costs that they've outlaid, and the result is a further assignation of the FIT payments to some finance house in exchange for a capital payment. The finance house, of course, doesn't take over the maintenance obligation of the solar panels. And I pulled out an article here as early as 2012 in The Guardian. The existence of a rent a roof contract was preventing sales of properties because of difficulties obtaining a mortgage, and the same would be true on remortgages as well. It's interesting to note that the UK Finance Handbook has guidance for England, Wales, and Northern Ireland only. It doesn't offer any guidance for Scotland in relation to rent a roof problems. So it would appear that UK Finance considers that the problem doesn't exist in Scotland because it's not possible to register a lease. But in England, what is required are the microgeneration certificates, and I'll come to them in the checklist that follows at the end of this, and proof that the installer was a member of a code of practice relating to the installation of solar panels, and evidence that the lease has been drafted in a way that doesn't create any priority over a security granted under the handbook. So next I'll come and deal with Green Deal. Green Deal was introduced by the government not only in relation to insulation and solar panels, but other home improvements, microgeneration, and so on. And the contractor was paid by government. The money paid by the government, however, was a loan, and that loan was repaid over the next 25 years through higher electricity payments. So it's a singularly bad idea, particularly where energy costs are now so high, to have to pay more over 25 years to repay a loan. The difficulty with these higher charges is that they will transmit if someone changes their electrical supplier, and they will transmit to a new occupier of the property on transmission of the property. So it makes absolutely no sense at all, the Green Deal. How the government could have thought that this was an appropriate scheme, I simply don't know. So in the Scottish Standard Clauses, 5th edition, section 29.3, the possibility of any Green Deal payments are excluded. But just a little note of caution, remember to consider other home improvements and solar panels. It could be insulation, it could be a heat pump, and so on. So just bear that in mind and make sure that evidence is provided, if possible, about Green Deal. And then finally, we come on to a sort of checklist for conveyancers where solar panels are installed, because the standard clauses don't really offer any guidance as to what to do in that situation. So first of all, if there are solar panels, you should be looking to obtain microgeneration certificates. And there would be two. One, that the installer was part of a code of practice, and that he was a member at the time of the installation. And secondly, the equipment should have its own microgeneration certificate. And I've put on the slide there the symbol for microgeneration certificates. If there is a feed-in tariff contract, obtain that contract, but don't try and interpret what payments are due to the purchaser under that contract, because that's not something that a conveyancer has any knowledge of and ought not to be seeking to explain something out with their competence. In relation to the panels themselves, the inverter, which seems to be the piece of equipment that is likely to fail, and any other ancillary equipment, it may be that there is a collateral manufacturer's warranty that's valid for a period of years. It's unlikely to cover a period of 25 years. The installer may have issued a warranty, and the installer may have some sort of backup insurance. So the installer's warranty and backup insurance are similar, I guess, to what you look for in relation to timber preservation companies. So there are some points to note where there are solar panels, and they would be equally applicable in respect of other microgeneration systems, such as a small wind turbine or a small hydroelectric scheme on a burn passing through the property. So I hope you found that of interest, and I thank you for listening to it.